Well, good evening. My name is Elizabeth Anderson, and I'm the Executive Director of the American Society of International Law, and it's my privilege to welcome you all here to Tiller House. See, many of you were here just a few weeks ago when we heard the pre-review conference briefing, and now we're going to hear the post-review conference. I'm really very grateful to our speakers this evening who could probably stand to spend some time catching up with their families and other things after 2 weeks away, and I'm grateful for you spending a couple of hours with us here tonight to brief us on what happened in Kampala. And it's also a great privilege to join again with John Bellinger and the Council on Foreign Relations in a series of events on the International Criminal Court. And John, as you know, is a partner at Arnold & Porter, former legal advisor at the State Department, and most importantly, from my perspective, is a counselor to the ASIL Executive Council. So without further introduction, I'll turn it over to John to introduce our subject and our panel. John.
Thanks, and thanks, Betsy. And for my other hat, I should probably also mention I'm a senior fellow in international law at the Council on Foreign Relations, which is co-sponsoring tonight's event with the American Society of International Law, thanks to a generous grant from the MacArthur Foundation. So it's wonderful to have Stephen and Harold back so quickly, having gotten back from Kampala. Looking around the room, this is a lot of fun because I think and therefore I suspect Stephen and Harold know almost everybody in the room, which does mean that you're not going to be able to get away with very much when you try to explain what went on with Kampala. You've got a lot of people who are experts on the subject, including a number of people who were actually in Kampala. So it will make for a good discussion. And many of you know that both the American Society on International Law and the Council on Foreign Relations have had active projects focused on the International Criminal Court during the last 18 months, both sponsored by the MacArthur Foundation. The American Society had a task force that was chaired by Will Taft and Judge Pat Wald here in the front row that kicked things off after the new administration about where should we go generally with the court and generally recommending greater engagement with the ICC while recognizing and indeed not recommending that the U.S. try to become party anytime soon. Professor Matt Waxman of Columbia University, who is also here, and I have been directing a program on international justice at the Council on Foreign Relations, and we, with the help of Vijay Padmanabhan, produced a council special report about a month ago with quite specific recommendations for the U.S. negotiators going into Kampala. So, of course, we're going to be very interested to see how our negotiators, in fact, did. Both of these documents, I think, are available. They maybe are now historical, but we think that both the ASIL Task Force report and the Council on Foreign Relations report have got some good and useful background, and they also talk a good deal about where we ought to be taking things from here. I am surprised, and I was saying to Andrew Keller here that he was surprised as well that there's been so little press about the review conference. This is a great pain to all of us who believe that the world revolves around all of us at the American Society on International Law. The reporters in the room, and you know who you are, we know that you, in fact, are waiting just to write major reports about this because this was a significant review conference. And I hope that it does get the attention that it deserves. Candidly, the issues, particularly on aggression, are complex. And therefore, I think it is important that Harold and Stephen are here to talk about some of the details, and I hope it does get reported. From my point of view, having dealt with these issues for a long time, it looks like, from the U.S. point of view, that the conference was a great success. Unlike the Rome conference, where I think most of you know, the U.S. ended up being one of only 7 countries to vote against the Rome Statute, despite the very, very hard work by David Sheffer. We are happy, I think, with the results that came out here, largely through very hard diplomatic work by Harold and Stephen. The Council on Foreign Relations report recommended that the review conference focus primarily on what was called stock-taking, the buzzword which basically meant really having a review conference, reviewing the work of the court over the last 8 years, and in part so that the conference didn't end up just being a conference about aggression, which it really shouldn't have been, and which also would have resulted in dividing the United States from other countries. It's my understanding that, unfortunately, that didn't really happen, that it really ended up being a conference about aggression anyway. I'd like to hear from Stephen in particular about what happened on stock taking. I know there was some stock taking, but it sounds like there was not really much that was done. So the review conference ended up focusing on aggression, particularly on the definition and activation of the crime of aggression. The result seems to be something of a Chinese menu. Others might call it a dog's breakfast of triggers, filters, opt-ins, opt-outs that all seem to have addressed the concerns of some parties. I have to say, in my wildest dreams of thinking of all of the things that people might include, I would never have thought of all of these different permutations. The U.S., though, was largely successful, in fact, was completely successful in avoiding activation of the jurisdiction of the crime of aggression, which, as we had said in our report and that the U.S. government had said, was an absolute red line for the United States. But it wasn't at all clear that we would get that coming out of the conference. Nonetheless, the prosecutor will have jurisdiction over the crime of aggression with a relatively bad definition starting in 7 years, and that's something that could place a large burden on Harold Koh's wobbly bicycle and could complicate coalition operations in the future. So with that introduction, we look forward to hearing from both of you all. Harold and Stephen.
Well, first of all, some of us like Chinese breakfast.
So it's a Chinese menu and a dog's breakfast, and I was very careful not to say that maybe there is the two coincide.
Well, let me break into 3 parts. What were our goals? What happened? And how did what happened meet or not meet our goals? I think when I came here before, a month ago, I said that we were trying to work with 3 policies of this administration. The first is a policy of principled engagement with international institutions, including those that we had been disengaged from in recent years. The second is a coherent approach to institutions of international criminal justice. We thought it made little sense to have a policy of support for ad hoc criminal tribunals prosecuting genocide, war crimes, and crimes against humanity, and then to have a different kind of relationship with a standing institution that performs the same tasks and indeed will likely be delegated the task when the ad hoc tribunals go out of existence pretty soon. And the third, with regard to the crime of aggression, is ensuring that in an age in which the United States is obligated with its allies to engage in lawful uses of force, that those lawful uses of force remain acts that we are able to do, particularly in situations such as humanitarian intervention, where you wouldn't want these kinds of things to be deterred. You wouldn't want the next Rwanda intervention that didn't occur to be deterred by an overbroad, however well-meaning crime of aggression. This meant that we were focused on a number of things. One is, what were the consequences inside the court from the outcomes of the conference? What would be the consequences outside the court? Would there be chilling effects from outcomes that were adopted? And would the United States have breathing room early in the time of its re-engagement with the court to absorb the changes so that we could have a sustained policy? And I think if there was one overriding objective, it was to try to stabilize our policy toward the court. Since 1995, there's been a series of policies. In 1995, President Clinton said he favored the concept of an international criminal court. In 1998, we did not sign the Rome Statute. In 2000, we did sign the Rome Statute. In 2002, we unsigned the Rome Statute. We went to a policy of overt hostility toward the court. By 2005, we were in a policy of coexistence, and then the Clinton administration began. And whatever you think, it's not good for the most powerful nation to have such a shifting series of policies toward an institution that's evolving and is going to exist. So that was the background. What happened? Well, during the 2-week conference, we engaged with the court, the state's parties, observer nations, NGOs involved in international criminal justice. We sent an interagency delegation that included state, justice, defense, NSC, the uniformed services. And there were 3 basic outcomes. First, stock-taking, support for the court's core work on genocide, war crimes, crimes against humanity, and a particular set of issues, positive complementarity, state cooperation, peace and justice in the interests of victims. And Steve Rapp certainly can say more about these, as he was deeply involved with all aspects. The second, the adoption of the so-called Belgian Amendment, which is a crime prohibiting the use of certain weapons in non-international armed conflict, particularly flattening bullets when used to needlessly aggravate suffering. And then the third, the crime of aggression. Now, when John says that it became an aggression conference, it actually didn't feel like that. We were there for 2 weeks. Almost all of the first week was devoted to the other issues, and it wasn't really until the second week that the aggression issue came onto the table. The outcome on aggression, though, we think served our core interests. We ensured total protection for U.S. armed forces and other nationals going forward. The court can't exercise jurisdiction over the crime of aggression without a further decision, which will not take place till after January 2017. The prosecutor cannot charge nationals of non-state parties, of which we are one, with a crime of aggression. A state party that ratifies an amendment can opt out. So the allegations they committed aggression can't be the basis for an ICC investigation or prosecution. And we secured an outcome that ensured that the U.S. and non-state parties would be treated the same, which was a major point of principle. Specifically, in no case can jurisdiction be exercised with respect to acts committed until 1 year after 30 states parties accepted the amendment. And then there are 2 channels by which aggression can be prosecuted if and when the crime does come into effect. One channel goes through an exclusive Security Council trigger, which the U.S. had been urging. The second goes through a prior Security Council review with 3 conditions. If the Security Council doesn't make a determination that aggression occurs, the prosecutor has to offer a reasonable basis for proceeding. That decision would require a majority vote of 6 judges, and the Security Council would still have the authority to stop the prosecution with a red light Chapter 7 resolution. The net result of this was that the crime of aggression was put on the back burner for the next 7 years. And we think this accomplished the basic goal that we were focused on, which is giving the breathing room for the court to get stronger and focus on its core crimes. We have a non-final approach which takes the issue off the table with a notional solution that can be re-examined. The definition we thought was flawed, but a number of understandings were adopted that can be used to make sure that the definition applies only to the most serious cases. We do think the final resolution took insufficient account of the Security Council's assigned role on aggression, but we can continue to work on this going forward. I think the big picture is we are the country of Nuremberg. Justice Jackson is one of our most esteemed legal figures, and that therefore we had an important role to play in figuring out how a crime of aggression could be successfully and responsibly applied. I think the chance of a prosecution of U.S. officials is 0 at this point. The chance of a chilling effect is as close to 0 as you can get. And on this basis, with this issue being put off, I think it's not the time for this country to adopt a defendant's mentality toward a set of issues on which we have very strong interest in promoting accountability and ending impunity. So to paraphrase Churchill, it was not the end. It was not the beginning of the end, but it did feel like the end of the beginning of our 12-year relationship with the court. We reset the default from hostility to principled engagement, and we think that that principled engagement worked to protect our interests, to improve the outcome, and to bring us renewed international goodwill. We did not want the story of Kampala to be the U.S. against the court. That was not necessary. We wanted the story to be the U.S. engaging with others interested in a responsible approach to international criminal justice, leading the court in a responsible direction, and we think that's what happened. As one delegate put it to me, it's so good, he said, for us to be seen, the U.S. to be seen, as part of the solution and not part of the problem. And I think that's what we take away from our time in Kampala.
Stephen. Well, thank you very much, John, for the invitation. You indicated perhaps that the first week and stock taking was not that important, and indeed there wasn't a lot of reporting from it, but I think it really set the stage for what happened in the second week. We were talking about a fledgling ICC, which has not yet finished its trials. It's 2 people on trial, or 3 people on trial, one for child soldiers, the other for a single massacre in Ituri. And a lot has to be done to make this institution effective in going after atrocity crimes. And there were 4 extremely well-attended sessions dealing with each of these topics, in which I'm not sure it was our doing, but we certainly pressed to include a lot of people from the ad hoc tribunals. And whatever you can say about the ad hoc tribunals and their slowness and the expense and everything else, the ad hoc tribunals have dealt with more than 200 accused and have rendered judgments against heads of government and have tried chiefs of state and have found people guilty of genocide and war crimes and crimes against humanity. And there's a lot to learn from them. And so in each of these sessions, there were people that had that kind of experience. We, during these sessions, particularly on cooperation, emphasized the point that the ICC doesn't need to limit itself simply to state parties to look for cooperation. As I noted when I was in Sierra Leone as chief prosecutor, only Sierra Leone was obliged to cooperate with us. Eventually, in the Taylor trial, specifically under a Security Council resolution, the Netherlands had to cooperate, but nobody else had to do a thing, even return our phone calls. But we succeeded in getting assistance, contributions, but also protection of witnesses, sentencing agreements, and finally the sort of political and diplomatic support we needed to arrest the chief of state and have him transferred to our trial. And so we said, you should make sure that in dealing with cooperation, you seek the assistance of non-state parties or non-party states. That was included in the final resolution, and that was consistent with what we had said in March in our intervention at the resumed ASP session in New York, where we said that we were prepared to meet with the prosecutor to find ways that we could support and assist the prosecutions that the ICC had undertaken so far. And that willingness and the discussions which we carried forward there on particularly issues of witness protection, I think was very, very well appreciated. Additionally, we emphasized the complementarity piece, which of course fits our tradition of as a donor toward rule of law programs. And one of the sessions that we were the most excited about, not just because it happened in Kampala, but because it happened at all, was a session that we sponsored with the DRC government and with represented by their Minister of Justice and by the Norwegian government, a major international donor, on complementarity in the DRC. I mean, obviously, DRC is the only place where they've arrested anybody in the ICC, and they have these 3 people on trial and a 4th coming. But of course, we all know that there's massive ongoing violations of international humanitarian law, targeted killings of civilians, thousands of rapes a month in the Kivus. And so there's no way that a few cases in The Hague are going to solve this problem, no matter how effective the ICC becomes. It has to be done on the ground. You have to strengthen the national system. You've got to be able to go after not just the low level, but the mid-level and even higher level people. And you have all sorts of international donors that are in there helping in one way or another, sponsoring a mobile court here, an initiative there, in a totally uncoordinated way. And if we sort of pool our resources, we can make this idea of complementarity work. And it was extremely well received. We had victims and civil society people there from the DRC, women who'd never met their justice minister, who ended up in an engagement and discussion with him that went on into the night. And we've resolved now to meet in Brussels to coordinate our various aid programs in accomplishing the rule of law in these humanitarian law cases in the DRC. And all through this time, I mean, I was meeting, and other members of our delegation were meeting with victims groups and people associated with achieving justice on the ground. And I think that message, and which is so consistent with the bipartisan support we've had for these kind of assistance programs, was I think very well received and very helpful when we dealt with this aggression issue. Now, of course, one of the ways that we were talking about the aggression issue, and on which we had received enormous traction, was the fact that if this court takes on aggression, if it starts dealing with so-called manifest violations, and it's unclear what those might be, with a border dispute where Colombia crosses the border into Ecuador and hits a FARC camp, and the victimized country wants a prosecution, if it starts getting involved in those kinds of cases, it's going to make enemies. It may make some temporary friends. It'll find it much more difficult to get the cooperation, which is so difficult even in atrocity crimes, as we've seen. I mean, 13 arrest warrants out there, only 4 arrested so far. But to get cooperation in crimes of aggression, where there's political issues about who hit whom first, who was responsible for the rebel group that came over, where the border is drawn, all of these kinds of questions would make this court much less effective in dealing with atrocity crime. And in the weeks leading up to the event, there had been a letter that had been issued by 50 international human rights organizations that had been addressed to every foreign minister of every country that ratified the ICC, saying, go slow with this one. This is something that this court may not be ready for, and if you do it very carefully. And so we had that, I think, context when we went to deal with the crime of aggression. It was, Harold, in terms of our division of labor, I was dealing with the engagement aspects of this, and Harold was dealing with the aggression negotiations. That we were all involved, and Harold mentioned our interagency delegation. This was. I just heard we didn't have the largest delegation in The Hague. Maybe the Dutch had one more than we did. But it was an enormous advantage that we had people there from the services, that we had people there like Bill Lietzau, who, as I often said, was worth the rest of us put together because of the respect that he has from Rome and working on the drafting of Article 8 and the elements. We didn't have we had people there. We had clear instructions that we could work within. We met every morning at 8:45. There was sometimes maybe some tactical differences, but no real differences in substance. And we were all working together to make sure that our nation's interests were represented, and that we were indeed representing what we think is our finest tradition from Justice Jackson and from others that fought for accountability for these crimes. And so it was a very effective effort on our part. We were dealing, however, with a difficult challenge in the world. Our major position was, of course, we shouldn't allow this court to get into the area of aggression without a Security Council filter or even a trigger. No way they could even open it without the Security Council saying an act of aggression. And our British and French friends were constantly saying this is a matter of principle. Article 39 of the UN Charter says that the Security Council has to determine whether an act of aggression has taken place. But of course, the Security Council is one of the least popular institutions in the world. There are only 5 countries that really like it, and only 2 of them had a vote. And so we had to deal with that reality. And there was a number of countries that took a principled position. Absolutely, this cannot go forward with a Security Council filter. But we had early on with in this case, our P5 allies, pressed constantly the argument that for something like this to occur, it needed to occur by consensus. And indeed, I think very sound reasons for that, for on all sorts of bases. The crimes that were adopted in Rome in Articles 6, 7, and 8, every single one of them by consensus. I mean, we might have opposed the treaty in the end, but we were deeply involved in defining those crimes. And the elements, all by consensus. And now we were getting into this crime of aggression on this sort of politically negotiated definition, which as a prosecutor didn't sound to me like anything that I could prosecute. I mean, I didn't know how you put this together. And we started with countries saying, well, we reached a consensus on this. That part is done. And but, because we really had shown our commitment to the process and to international justice, we said, wait, there needs to be an understanding of several things. And we did accomplish some understandings, even though this had been written in stone. No understandings at all. I mean, we got one saying that it's not the customary international law. We got one that's saying there's no obligation on states to do it themselves for acts of aggression committed by others. I mean, we faced the prospect that states would start putting this into their statute and prosecuting some foreign leader that landed in their capital for aggression, which they'd been a victim or somebody else. We got that out. We in terms of this character, gravity, and scale, said, well, not just character, not just gravity, not just scale. It had to be a combination of them. And then significantly that it had to be the most serious and dangerous form of the illegal use of force. So we got those understandings in there, and I think that was a reflection of the fact that people realized that we didn't want this to affect potentially the kinds of uses of force that could be protecting people. So that was a positive aspect of it, and it was constructively negotiated and unanimously agreed. And then we had to move forward with this question of entry into force. And when we came, we kind of hoped that maybe people wouldn't want to go forward, but there was an enormous impetus to do it. And we were looking at a situation where if it had been blocked, it would have been back, and back very fast. It would have been probably back in December. Now, we had the advantage that there were only about 85 countries there, and it took 74 to pass it. Absences, abstentions, no votes, all counted the same. It had to be 74. So it would have been hard to hammer this through on a vote. But even then, the understanding had early been made. This needed to be a consensus. On the other hand, in New York, in December, with 111 countries all there, because they've got missions to the UN there, they can send somebody over, it might not have been in that situation. So we saw that reality, and I think worked very hard to make sure that provisions were in there that protected ourselves and our allies who may be opting out on this. And those, I should note, are in there solidly. Whatever happens in 2017 by the decision that is made then, these will be in the statute to the extent that this provision is ratified at all. So it'll be much more difficult to revisit that. And then, in the end of the day, the decision about whether to go forward at all, the decision about whether maybe to go forward with the Security Council for a period of time and consider the other options later, will take the same vote that could have been taken in Kampala. Hopefully a consensus, but at least 2/3 of the membership voting for it. And so I think we have an opportunity to continue to talk about whether we want to go there and to understand when we might want to go there. And as I think Harold said, what happened at Nuremberg, what happened at Tokyo, we're very proud of. When you do have aggression of a kind that destroys whole societies, kills in excess of 50 million people, as we saw just in Europe in World War II, that it is appropriate to have prosecutions in those cases if you can get the people in custody and do what needs to be done to actually make cases. And but what we don't want is this court to be involved in sort of border conflicts and other things and questions of national honor, crimes in which it's really the state as a state that is the victim, as opposed to civilians and populations and large numbers of combatants even who are the victims. And so I think we still will have time to look at this issue and determine how to work with it and how to make sure that when these cases do go forward, if they do, that the right cases go forward. But in the meantime, the good news is that this court can now focus on getting it right when it comes to getting people in custody, when it comes to arresting Joseph Kony and the people that have committed horrendous crimes in Uganda and are trailing their way into the DRC and CAR committing similar crimes. And this court can become a more effective institution with our support for cases that we believe are in our interest. And so far the cases that it's taken on have not been those that we feared that might be politically motivated, but the cases that cried out for justice. And as engaging with this court and engaging with the prosecutor, I think we have a much better chance of ensuring that will remain its focus, and that the promise that we made at Nuremberg of holding to account great leaders for horrendous crimes that we continue to fulfill in the former Yugoslavia and in Rwanda and Sierra Leone and elsewhere, that's raised such expectations among victims around the world that can be fulfilled in part by this court. Thank you.
Thanks, Stephen. And Harold, let me just start us off with a question for each of our panelists, and then we'll throw the floor open. Harold, first a question on aggression. You've pretty much briefed us on the what happened, and I want to ask you about the how it happened and why it happened. My sense, and you can dispute this, but my sense going in was that the United States was really very nervous about what might happen. As you know, because I asked you about it last time, our report had recommended that the U.S. delegation...
We had it all the way.
be headed by a senior official like the Secretary of State, because that would have been the best way to really state, we are back. But the one reason that you didn't do that is that you were a little nervous about having the Secretary of State associated with what might have been a failure. When Matt Waxman and I went around Europe sort of field testing our recommendations, people said, yes, we are delighted that the Obama administration is back. I think it's not quite fair to say that the default was hostility, because as you said, there had been a fair movement in the second term, which countries had appreciated. But Matt's and my sense was, yes, they were delighted that the Obama administration was ready to engage, but they were not ready to move 1 inch towards you. They wanted you just to move towards them. And yet, you've ended up being successful in pulling all of these pieces together. So I'd be interested to know sort of what dynamic it was. There were 7 years of the Princeton process in which, while the U.S. wasn't there, we had other countries fighting hard on the definition, on the trigger, and there was an agreement. And then suddenly, when push came to shove, it did come together in a way that was much more positive for the U.S., frankly, than we expected. So can you give us some of the how and the why?
Yeah, I think the why engagement works. If you stay away from the Princeton process for 7 years and it comes out in a way you don't like, it's very hard to change it, because then people say, why weren't you engaged? Once you engage, you can accomplish a lot in a much shorter period of time. Now,
But let me push you on that. I mean, we had the British, we had the French, we had the Russians. They were engaged. The premise to what you're saying is that the U.S., in fact, is the indispensable party?
I think people listen to the U.S., and if they think we're part of the process, we can secure greater protection for our national interests and build stronger institutions through engagement. It was a mistake not to go to the Princeton process. It was a mistake not to make the changes that we knew we wanted to make or suggest them earlier, and we had to deal with that. And I think that it showed the kinds of, the notion that they won't move an inch. Look at the outcome. There was very substantial movement toward our positions and taking our concerns into account once we started to engage. Now, why doesn't the Secretary of State go? She was busy. Very few countries were represented at the foreign minister level. Most were represented at the legal advisor level. But I think that there was an important procedural dimension of this that I didn't fully appreciate till we got there, which is the dynamic of a review conference. First of all, we emphasized from day one the norm of consensus. And we emphasized from day one, this is day one of our engagement, that a review conference is a constitutional event. And it's a constitutional convention and should not be run through rules of ordinary politics, which means there must be overwhelming agreement that some organic change in the court is going to take place. And that meant that review conferences are special because the states parties can actually focus on issues that are good for the court, which means that all the different dimensions of this ought to be discussed. And I think what ended up happening was we got to Kampala. The first week, much of it was spent discussing the need for consensus. The need for consensus gives all the different voices an unusual say. And then the idea was the resolution at the review conference should not be revisited at every routine meeting of the states parties, which is why we ended up with a result, I think, that has now created a norm, procedural norms with regard to how the statute will be amended in the future. Do you really want an international criminal court in which two-thirds majorities vote whatever crimes two-thirds of the states parties might want to do at any particular moment at a meeting in which they're discussing all the routine business? It's so important to separate constitutional politics from ordinary politics, and that's what was done, and I think that was a very valuable precedent. There was also, I think, a feeling among those participating that this was a moment in which they needed to do a serious review. And there was an interesting split between the diplomats and the international lawyers. Let me put it that way. Many of the diplomats wanted to complete what they saw was the unfinished business of Rome, where most of the international lawyers want a court that works. And the 2-week review conference forced them into dialogue with each other. And I think that was tremendously helpful because the prosecutors and the judges and the NGOs were almost uniformly skeptical of the need for the crime of aggression. As one prosecutor put it to me, he said in disbelief, why did they want to land on Mars when they haven't proved they can land on the moon? In other words, people were much more interested, the diplomats, in talking about hypothetical crimes that could be prosecuted than talking about how to make the court stronger as an institution to prosecute crimes that were actually happening and for which there's very broad consensus about how they ought to be done. And I think what we've now done is having answered the diplomatic desire for a notional solution on the future-oriented issue to now have the chance to engage on the present issue and make the court a success. Somebody pointed out, and I have to go back and check it out, that in the similar period of time, the ICTY had 12 successful prosecutions, where the ICC has had none. So I think they can spend the next couple of years proving that they can land on the moon. And I think it's certainly in our interest to do the kinds of things that make international criminal justice institutions work. Obviously within the constraints of laws that we have here on the books and other kinds of policies, but to make sure that particular cases serve our purposes. I mean, there's nobody in the world that I know who believes that the world is safer because Joseph Kony is on the loose recruiting child soldiers. That's not an ideological issue. There are important uses for institutions of international criminal law, and now we have a number of years in which we can really explore those with regard to this young institution.
Thanks, Rob. And so, Stephen, one question for you and then open the floor. That's a good segue. The question is essentially, so where does the U.S. now go from here? our report recommended, and I think this was the administration's position as well, that if we are successful at Kampala, then the U.S. should, in fact, work to engage with the court to support it in its endeavors. That's not, I think, a universally held view within the administration. I think it's held by you two, but I do know that there are concerns inside the military that even if we support the court in certain what would seem to be obvious cases like Coney, and we legitimize it one day, we might have to be criticizing it the next day if the unthinkable were to happen and we get one of these national prosecutors who's been prosecuting our military in national jurisdictions who suddenly takes the court in that direction. But so the question is essentially, where do we go from here? And particularly since, all of us in this room know that sort of with the euphoria of the last 7 years going, all of us know this court actually has got some serious flaws. So where does the U.S. now go in trying to support the court in the appropriate cases, but bearing in mind that it has got these flaws? And I guess throwing in one more thing, which was Will Taft's question last time, given that we have domestic legal constraints, which are unlikely to be changed in the American Service Members Protection Act, that actually prohibit cooperation, although we do have the exception in the Dodd Amendment. So.
Well, I think when we spoke in March, we spoke sincerely, and it was based upon an interagency process. You're correct that there were people still who fear that the court, by becoming stronger, might be a greater danger to us in the future. But that was based on the idea that this court could somehow, die in its infancy, and it didn't. It went forward to today have 111 ratifications. It'll certainly gain dozens more in the not too distant future. It's the institution which, as I've said, will deliver international justice to the extent that it is delivered. When there is no ability to do it at the national level, even with mixed courts or other sorts of approaches that may be more appropriate. Sometimes that just won't work. And so we, I think, have to be committed to the success of this court in cases involving mass atrocities. We want it to work, and we made a very clear decision that we are prepared to support it. Now, how to do that? One that involves meeting with court officials, which we've done, and seeing what they would like to have us do. And in that regard, as I noted here 5 or 6 weeks ago, our support to the ad hoc tribunals took, of course, the forms of being, dues-paying members of the UN and having our own employees in key positions, but also took significantly other forms of assistance as a key part of that, information sharing, work on the protection of witnesses, political and diplomatic support to ensure arrests and transfers and cooperation. And those same issues are on the table again with this court. As you know, we have the American Service Members Protection Act. We have another provision that prohibits direct funding, and we can't do anything that violates our law. Without getting into the details, there has been a legal determination that the provision of the American Service Members Protection Act that provides that we can provide case-by-case assistance in cases involving serious violations of genocide, war crimes, and crimes against humanity by non-citizens, I think does provide some flexibility, perhaps not for general assistance, but for case-specific assistance, and also our strong interest in making sure that witnesses are protected that have vital information about mass violations. Whether the accountability will be achieved in an international court or in a local court or a mixture of the two, I think gives us the ability to look at options where we can dig in and help this court. And so we're working on that, careful that everything we do is consistent with our law, but also very much wanting the court to succeed. it's a bit frustrating. I will note, even when you deal with witness issues, the way that the witness and victim support is divided between the registrar and the prosecutor is different there, and trying to find exactly the place where we may be able to be of benefit is challenging. But it's not just us, it's allies and other donors that are stepping up there, because when you deal with these situations, the court itself, with its resources, can't do the job. I mean, there are too many people that have to be protected for too long a period. There's challenging issues in terms of the diplomacy you need to move people from one country to the next, and particularly when you're dealing with a mandate that calls for essentially to prosecute people at the top level, and where you have to have inside testimony and those kinds of things in order to make your cases, the court needs help. And we want to make sure that it has that help. We also want to make sure that it does the job right. And so we're going to be engaging on that. And why? Because we want Coney, we want Bosco and Uganda, we want other people held to account. We want those cases to succeed. And so we'll do it for that reason. I think that will also maybe benefit us when we deal with some other issues. But the key question is making international justice fulfill the promise that we've been involved in giving in these other institutions.
Thanks. So the floor is now open. Do we have a microphone, or do we need one, Betsy? Or people can just speak? We do have a microphone, which I think is useful for the camera. So go ahead. Microphone is coming. Right here with the woman in the striped suit. Yep.
Hi, Heather Hamilton, Connect US Fund. I just want to follow up on your question, John, about where we go from here. We know that there was an interagency policy process, and I just wanted to ask about whether that process has concluded or whether that is ongoing, and whether we can expect a statement from that process. You've both made some very clear statements, both in press statements and tonight, about where we do go from here, and I was just wondering if there is a more formal end to this, or if we're at the end of that.
Let me just say one thing. I should have said this up front. We are not on our normal Council on Foreign Relations rules. We're actually on the record tonight. So just so you all know this, but I just want to make sure that the members of the audience know as well. Yeah.
I'm not sure that that's necessary. I mean, we've stated in a number of interventions what our policy and approach is, and we'll continue to do it. And in terms of the interagency process, it's ongoing. I mean, we like each other. We're going to be dealing with these issues. We're going to be having to weigh up questions when we enter into new situations, when the ICC opens the case about whether they're in our interest and what we can do. We already have other interagency processes that work on a regular basis with requests from the other courts, and some of it may be handled there. But it's a process that doesn't have an end, and as Harold said, we're just at the end of the beginning, and we'll continue.
If you want the statement from the interagency process, you just got it. We're the co-heads of delegation. It's a transparent process. Mike Sergala is here from DOJ. He can say what he wanted. He was in Kampala the first week. We had close working relations with the Foreign Relations Committee, majority staff and minority staff. Mike Matler, Andrew Keller, they can contribute what they want to say based on their own observations. But, there are no mysteries here.
Judge Wald.
I've got a two-part question. First, I think you can speedily answer. You talked a great deal about consensus and how important that consensus was as one of the principles that was guiding your efforts over there. What was your impression at the end of the process? Because we all know there were people, and you've alluded to it, and we're all familiar with, who really wanted aggression, or felt they were working on it with the working group over a long period of time. Do you feel that they were, at the end of the conference, that those people were pretty well reconciled to a consensus modem, even if it meant nothing was going to happen for 7 years? Or basically, do you think there's any possibility of a rift among people in the Assembly of State Parties based on what happened there?
Well, Judge, the power of consensus is if you want to break it, you can. And there was a moment right at the end where he said, here's the outcome. Anybody wants to break consensus, now it's time to speak. Nobody did. Now, how many people in the room were 100% thrilled about everything that happened? Who knows? But the power of a rule of consensus is it suggests that an organic change that affects the institution shouldn't be done based on shifting majorities and contested votes.
Okay, just if you pardon me, this will be quick too. When you talked about stock taking, did much of the discussion or any of the discussion focus on ways in which the court itself could be operating more efficiently? This is a follow-up to John's question, because whenever you talk to a press person, you usually get immediately challenged about the length of delays. Now, we all know the many factors that have made it more difficult for the ICC, the victims' rights, et cetera. But still, it is a kind of a looming presence, at least in popular impression. And I wondered if any of the discussion got into how better the court might be managing its own docket, its consensual docket.
I mean, that's a very good question. And as we began to engage, we saw memos from some state parties that really did want to get into that topic. But I think the officials in the court thought that the approach should be the broader one that to a large extent focused on external factors. I mean, the topics were cooperation, getting states to help you, complementarity, which is, should the court be involved as a development agency, and if it can't be, how does it coordinate and make sure that the right thing is done at the national level? Peace and justice, which of course is a broader issue, which can get to the question of whether there's selection of cases or deferrals, and then the victims and affected communities. I think that was probably the one that came the closest to the internal operation of the court, how it manages victims' compensation, which of course is a real challenge, victim participation, which is something we're unfamiliar with in the United States, which has become a big part of the court, but obviously complicates the proceedings to an enormous extent, and the compensation. So there was a little bit of discussion of it. But I think everyone in the Assembly recognizes that there are challenges in terms of the court's own operation, and certainly in the NGO community. I mean, I don't want to quote him specifically, but if you know Bill Pace, who heads the Coalition for the International Criminal Court, it's 2,500 coalitions. He periodically speaks about these sort of internal questions and the need for the Assembly of States Parties to take a more active role. And certainly, I think, as we engage with the court to the extent that we can, and it'll be on potentially victims' issues, we're going to be wanting to have an influence on some of those factors. But I think you're quite correct that there's an agenda there, really an internal agenda that's going to have to be dealt with, and that was barely scratched at this conference.
Here and right here. Sorry, you still got your question? Yep.
Actually, my question was asked, so let me just ask another one. Heather stole my question. This is Don Krause with Citizens for Global Solutions. The outcome, in many ways, was a compromise. And do you see any positives regarding the outcome on aggression? That the fact is that there is now some acceptance of this definition, and for countries that want to be able to utilize this, that this is in some ways a precedent moving forward, and that we do have this concept that's now more enshrined than it had been before this conference. Do you see any positives coming out of that?
Well, I mean, I think it's positive in the sense that the issue has been resolved. How it goes forward. What we discovered about the aggression issue is that a lot of people were interested in it as a matter of principle. Sometimes they saw it as something that might have affected their history if it had existed at the time. But as going forward, when we discussed that with people and talked about how a case would happen and how difficult it would be to get cooperation and all of the challenges of actually making these cases, I think we actually prevailed on the argument that prosecutions for aggression should be rare. So I think the main accomplishment here is that to the extent people saw this as an agenda item, there was Article 5 with those 3 sets of crimes, and this 4th one hadn't been dealt with, we dealt with it. Now, of course, there's still a lot of other things that have to be done in terms of activating it, but I think that frees the energies that were spent on this to work on other issues.
Don, I think that the outcome showed a certain amount of self-awareness on the part of the state's parties. Self-awareness that they were not ready to have a crime of aggression go into effect today. Awareness that they were not prepared to make a final decision on aggression before the court had proven itself in a more traditional class of cases in which there have been successful prosecutions before the ad hoc tribunals. Self-awareness that the definition that had come out of the Princeton process needed understandings to be clarified, and self-awareness that the court should not adopt a crime of aggression with no filters, because that was the approach that was rejected, even though it was urged by some. Now, those are do-nots, and what will eventually emerge when this issue is reopened will take place in a different place with a different background and a different history of performance and a different set of engaged participants in the conversation. But I think that the self-awareness was helpful. There turned out to be a desire on a large group of countries for some completion, but it turned out completion didn't mean locking in stone for all time something that was untested. So they satisfied the desire for completion while leaving important issues open that weren't ready to be decided.
I'm going to go to the 2 people here, first the man and then the woman, and I got VJ and Edwin on my list and one back there. Yep.
Thank you. Brett Schaefer with the Heritage Foundation. You mentioned the understandings, and I was kind of interested because you mentioned that this is something somewhat new for the Rome Statute. And I wonder if you could comment on exactly how binding you think the understandings are on the actions and the interpretations of the court on the crime of aggression going forward. And the second issue is I'm kind of fascinated by the declaration to opt out of the crime of aggression of states parties that actually ratify the crime of aggression, or the amendment to the Rome Statute on this issue. How do you think that's going to work? I mean, do you think it's an instance where they can just declare any time they want to opt out? Would it be for a limited time period? Would they have, if they choose to declare, would that then have to be kept in place indefinitely in order to preserve the immunity from the jurisdiction of the court for a specific time period or a specific act? I'm just kind of interested in how you see this as being interpreted by the states parties during the review conference.
Well, those are fascinating questions, and we could spend the next 7 years thinking about that. And tell me that's not a good outcome, because the fact of the matter is that there are many, many pieces of this notional solution, any of which can be changed. I'm sure there will be many articles written about this. Things that were decided at the heat of the moment could involve gaps or lacuna, which could be pointed out by astute commentators like those here. And presumably this will come back up at another review conference where we point out that the matter was not final, needed to be revoted, and that some issues that have to be addressed, which weren't visible in Kampala on the night of June 11th, need to be addressed.
And just in terms of these provisions, this opting out, and of course the language is complicated. It says and that it will apply to a state unless the state has previously declared that it does not accept such jurisdiction by lodging a declaration with the registrar. And understand the state, a new state coming in can lodge that before ratifying. And then the withdrawal of such a declaration may be effected at any time and shall be considered by the state within 3 years. We have ambiguity on that, but presumably might require states to consider this every 3 years. We'll have to see what the interpretation is. But fundamentally, I think you have to keep in mind that this withdrawal affects the non-security council cases. Clearly, as has been the rule with the ICC from the beginning, and as we saw with Darfur, if the Security Council provision, Article 15, TER goes into effect, and of course that doesn't go into effect either without a 2/3 vote or hopefully a consensus vote in 2017, that applies to all states. Just as it applies now to Sudan in the case of the crimes allegedly committed there, because it's essentially done by Chapter 7 of the UN Charter. It's this other provision where cases could come by state referral or by prosecutor acting proprio motu that states can opt out of. And we think there's a very good argument, and we might be in a position of suggesting to allies that they opt out of this aspect of it, recognizing that they are certainly willing to see any case that's brought by the Security Council implemented. And so I think this offers opportunity for diplomacy in the future. Those of us that had looked at the consent-based solution generally, which had been something that the advocates of the crime of aggression had pushed, from very early on, people were saying, well, we'll pass this in such a way that it doesn't affect countries that don't approve it, arguably doesn't affect, though they never made it very plain, it was going to be understanding language instead of statutory language, doesn't affect non-parties. But in this situation, you've got state parties who are willing to perhaps make a decision not to move forward in this way. And if we didn't have that, if we had state parties obliged to adopt it if they wanted to go with aggression, we could find ourselves in a difficult situation when we wanted to build coalitions. So I think here this offers us the option in the future, if this is implemented, to talk with countries and perhaps suggest to them that opting out might be a wise solution.
Thanks, Bridget Moix with the Friends Committee on National Legislation. I wonder if you could say anything more about the impact that the experience of the review conference had on your DoD colleagues who were part of the delegation. Obviously, going into a review conference dealing with the crime of aggression might raise concerns for people at DoD, but I would hope that engagement works and that being a part of the process and having some of their concerns addressed would perhaps help ease concerns that the Pentagon has had about the court. And I ask partly because having a DoD expressing more comfort or at least less concerns with the court would be helpful in sort of dealing with some elements in Congress and elsewhere that will still continue to oppose engagement.
Well, my colleagues here in the audience who were on the delegation can disagree, but I don't think there's a single person on our delegation who didn't think that we would not have achieved this outcome without the kind of engagement we had for the last couple of weeks. So I think everyone came away as advocates of more engagement. In fact, there was a feeling that the pieces that we had more difficulty addressing were ones that had been locked in when we were away. And it was very hard for us to, in fact, there's one of our DoD colleagues, Bill Lietzau, who in his intervention simply pointed out that we had missed an opportunity to engage and that was unfortunate. I should say that one advantage that we have in the whole process here is that the whole package was adopted by consensus, the understandings, the various filters, the delay provisions, the preambular language. And since everything turned on everything else, it's very hard to say that something that was in there is meaningless. It was every single piece of it was a critical part of what was decided. So I think that if we're looking for arguments that, an understanding is meaning, the package wouldn't have been adopted without the understandings. So there are obviously many interpretive issues that we can address, but I think it's the difference between legislation and judicial interpretation. There's only so far you go in a constitutional convention, and then, as you know, you adopt theories of interpretations for cases and controversies, and that's what's going to happen next, I think. But again, I welcome, correct me if I'm wrong, but I think that many of the DoD colleagues came away as the most enthusiastic on the notion that, for example, the Belgian amendment was a very good example. It involved a particular kind of weapon, and the colleagues on the delegation engaged on that issue, really brought about a result that we were, able to feel was completely consistent with our interests, and that was through very, very extensive conversations with the sponsors of the resolution, adjustment of the language, etc.
Edwin Williamson, former legal advisor.
My part of my question was asked by Brett Stevens, but Harold, I must say that I think that given the importance that you all have placed on these understandings, I don't think you can very well get away with just a dismissal that we'll let you know what they mean in 7 years. I think there's some very serious questions about them. So I think there's something I hope you will engage on.
Ed, we got them in there. We got them in there.
Okay.
We're not saying they're unimportant. In fact, the opposite. We're saying they're critical to the package. And I think the outcome suggests that they are, because you wouldn't have had the package without them.
Well, I heard the question is, a little better understanding of exactly what they mean. They're, at least on the Opinio Juris website, there are questions as to the validity and so forth.
Can I address this? Because it's fun to read these websites. But here's what happened, Ed, which is the definition was out there. The first week of the conference acted as if the definition was going to be all that was out there. The intervention I gave at the end of the first week went through all of the interpretive problems of the definition and pointed out understandings that we would need for us to be comfortable with an outcome. That led to the convening by the chair of a German-chaired understandings group that was attended by nearly every nation in attendance. We tabled a whole series of draft understandings, and the group sat around and went through and adopted some versions of those into the text, which became part of the consensus package. So I think you can draw your own conclusions from that, but they certainly are not meaningless. Whether you could argue in the appropriate case, and I'm sure a defense counsel or somebody will argue, relying on a blog, that in some way those understandings are not important, and the other argument will be made and it will be adjudicated.
Well, I'm not that good on the theology of customary international law, but I'm sort of puzzled by the understanding that says that this agreement that's going to be enshrined in law, I gather, is not going to be part of customary international law. I'd like to get a little better understanding of that. So the second question, Steve, if I heard you correctly, you said that these understandings, quote, will be in the statute. And again, maybe I misunderstood.
Well, no, you would have misunderstood me. obviously they'll be there as part of this legislative history for interpreting the statute. If I said to the contrary, I misspoke.
But on the first point, I think there are three crimes. There are three kinds of crimes: crimes against humanity, war crimes, and genocide, which have extremely well settled understandings in customary law and are jus cogens, and were before they were incorporated in the Rome Statute. And then there is a fourth crime, which is a crime of aggression, in which the definition was reached through a Princeton process relying on a reading from a General Assembly resolution, which relies on a political check, and where the only prosecutions that were successfully done in the past were for wars of aggression, not for acts of aggression. So that that understanding goes to the point that what is being adopted here is for the purpose of this statute only. It doesn't become jus cogens automatically. It's not automatically considered part of the jurisprudence of every country in the world. It's not subject to universal jurisdiction, etc. So there are many ways in which it could now be invoked, but the understandings certainly make it a lot harder to do so.
And I mean, very clearly, I mean, when you deal with this definition, which we didn't like, which had been agreed to by consensus, courts are going to need guidance. Certainly defense attorneys who are representing alleged aggressors will be coming in there and arguing that their particular accused isn't covered by this, and the legislative history decided by consensus will set forth these understandings. So they seem to me to be highly persuasive, and the option was not available to revisit the definition. Our allies in the United Kingdom and France thought this definition was just fine. They weren't about to go back and say that they'd erred in approving it. So we took the only avenue that we could by pressing for these things, and because of our engagement, we got them. We got something we wouldn't have had otherwise because of our engagement and the absence of the legislative history that we generally have, and clearly having been adopted by unanimity. I think these will be extremely important in the future.
I'm going to now do the following because I promised Harold that I would get him out a few minutes before 8, and there's always a little bit of hovering afterwards. So I'm going to take the questions that I saw, which is VJ, who was the drafter of our council report and was in Kampala, and the one in the back, and I will take one more if there was one. Otherwise, we'll take those two and let Harold and Stephen say the final word. Anyone else? Great. VJ and then in the back.
Okay. Great presentation. I do want to challenge, though, a little bit the sense that the stock-taking exercise was a really meaningful exercise in Kampala. And specifically, I found pretty disappointing the comments that were made by many of the African states in particular, and maybe developing states more generally, where it seemed like their real focus was on using the ICC as an institution to check the power of the Security Council and, say, the aggression debate. But when it came to actually talking about how to improve the performance of the court, they were very resistant. As you mentioned, they were talking about turning the court into a development bank in terms of assistance on complementarity, resisting also the very core tenet, I think, of the court, which is that justice is compatible with resolution of ongoing conflicts. And so my question sort of is, A, why is it that you took a positive spin or a positive takeaway from that discussion? And secondly, do you think there's anything concrete that states can push the developing states or African states in particular in terms of improving their record of cooperation with the court?
Just to take these two together. Okay. Yep.
My name is Ralston Deffenbaugh. My question is, how did the conference deal with the charge that the ICC has become the International Criminal Court for Africa?
Okay. Well, I guess those are really, to some extent, the same topic. I mean, we had the declaration at the CERT AU summit that sort of suggested that African countries were not going to comply with an ICC arrest warrant, even one that was mandatory on 30 of them. And then we brought a conference together in Africa. Given that context, given the concern that we certainly heard from our colleagues from the AU, et cetera, and then as a result of a discussion, a resolution was adopted that called for more intensive cooperation, that urged states to follow and implement the requests and the arrest warrants of the court. And so the bottom line is this meeting occurring in Africa, where there had been this at least attempted defiance of the court, ended up reaffirming the legitimacy of it. Now, of course, one can question these sort of high-level declarations and who's actually going to implement them. I know that. I mean, that's a fundamental problem of international organizations and resolutions. But there were, I think, some positive aspects of it that I was noting earlier. I mean, the fact that you had the ad hoc tribunals represented there talking about what needed to be done, and people were listening and responding to it. The fact that we move forward, I think, on the complementarity piece, not from the point of view of making this into a development bank, and obviously the Assembly of States Parties who support the court as members, 100 million euros a year, aren't wanting to use those monies for development. But I think all of us that worked in the ad hoc tribunals knew how important what, for instance, the ICTY has done in the former Yugoslavia to strengthen the justice system there and the expectation that's been created. And we need to look at that being done in each of these situations in the future. And that means drawing in the donors and coordinating their efforts. And I think that will happen to a greater extent because of this. It's still a little hard to figure out who's going to run that. Of course, we don't want people telling us what to do in these things, but I mean, I think that that we are going to see a greater focus on making complementarity work. It's not perfect, and of course, these kind of sessions where people get up and talk about their issues and their concerns, and then you try to come up with a consensus resolution, don't often accomplish a great deal. But I saw things that were positive there. And indeed, the agenda that was discussed there is an agenda that we'll be working on for a long period of time. And as we meet with people, and I was meeting with several African leaders today, they were very interested in some aspects of these recommendations, and the fact that I can go forth and talk about what we agreed to in Kampala and ask them to follow up on it, I think is positive. Not enormously positive, not an A+, but something that I think was good and a very effective use of that time. Indeed, most of those sessions ended far too soon. I would have had them go longer.
Harold Coe, last word.
Well, I agree with Steve that the basic way they tried to persuade people this was not a court for Africa was by holding it in Africa. And then starting with a series of statements by various African leaders and others about how much they favored and supported the core mission of the court. I think the most important point is the goal of this conference was to get people to focus less on hypothetical future fears and actually focus on real problems of an ongoing and existing institution, to shift from focus on differences of prediction to evaluations of performance. Now, what Vijay said is how meaningful was the stock taking exercise. How meaningful is a congressional debate? When you're watching it, if you watch C-SPAN at 3 a.m, as I occasionally do, sometimes you think, this might not be as meaningful as it appears. But it is a lawmaking and norm-setting exercise. And one thing that it did was there was in Kampala a sustained focus on 4 questions which have to do with what makes this court stronger. Is there state cooperation? Is there meaningful complementarity? What is the link between peace and justice? And how do victims participate in a way that advances the cause of the court without crippling the court in terms of its actions? And that was then linked to the question of resources. What pledges would be given to support the court in its core activities of making it a stronger, better court? And however rote or mechanical some of the things may have appeared, I think the important thing is they cannot now have a review conference and not do the exact same things again in a way in which you have 2 data points. For example, they created a framework for a crime of aggression to exist in a number of years without giving the court resources to deal with aggression. That's a serious question, but who knows how many aggression prosecutions they're going to have. So part of this is to force those who are thinking about this as a diplomatic exercise to think about it as an institution-building exercise and to adapt what they're doing to the reality of the situation. And I think the most important thing for all of us who were there was this, that there are things that keep me up at night and make me worry. But one of the things that's not making me worry is the idea that in 7 years, in the context of a review conference in which there are a reevaluation of this in light of performance, that after all the opt-outs, filters, and whatever are exercised, that this is going to create a major problem for American foreign policy in a situation in which you've guaranteed total protection of U.S. nationals. That's not one of the things that I need to worry about now for some period of time. 6 months ago, I didn't know there was going to be an oil spill in Louisiana. I didn't know there was going to be volcanic ash. 2 years ago, we didn't know there would be the most significant meltdown of the global economy since the Depression. Those are things to really worry about. But this one is one in which the risks have been placed into a manageable zone. We have a plan and a strategy, which is one of engagement, and we can go on and make this a more effective and useful institution that serves American interests.
Well, speaking of engagement, Harold Coe, Stephen Rapp, you have gone a long way, both in coming on May 14th to talk to us before you left and coming 3 days after you got back to tell us what you've accomplished. Thank you on behalf of both Council on Foreign Relations and American Society of International Law.